Alex here with my second video on legal nuts and bolts. This video is going to be on satisfaction of judgment. This isn't really connected to high conflict child custody. As I mentioned in my previous legal nuts and bolts video, this is really going to be something that applies to any kind of litigation. So a satisfaction of judgment is what's entered by the judgment creditor, the person who won a judgment, after the judgment debtor, the person who lost and has to pay a judgment in any kind of civil action. So I've had to enter these. I've sued two towing companies. No, I've sued two property owners that had my car towed because I won both cases. And what else? Verizon Wireless I sued once. And I did also have to enter this in my high conflict child custody case because I did end up getting a judgment on some arrearages that my ex owed me way earlier in the case. Anyway, once you're the judgment creditor, if you win your lawsuit and you get a judgment imposed against your opponent, the judgment debtor, you are the judgment creditor and you're owed the money that the judgment says is owed to you. Once the judgment debtor pays you that money, now in most of my cases I had to forcibly take the money. I might cover some cases on how, I might do some videos on how you can execute on a judgment to forcibly seize assets from a judgment debtor that doesn't want to pay you. Usually they don't want to pay you and you end up having to seize their assets. In all of those cases, including the one against my ex, I did have to end up seizing assets here and there. Once you're paid either voluntarily by them or after you take their stuff, you have to notify the court that the judgment has been paid off. This is an obligation on you, on the judgment creditor in Nevada. And the way you do that is by filing a satisfaction of judgment. And it's just like a single sheet of paper that just states that that the judgment has been satisfied, it's been paid off. And that matters because the credit reporting agencies, the courts don't report to the credit reporting agencies. Many people think they do, but they don't. The courts do not report to the credit reporting agencies. What happens is the credit reporting agencies check all of the dockets. So when the credit reporting agency checks and sees a judgment, they put that on that person's credit report. And when the credit reporting agency checks and sees a satisfaction of judgment, the credit reporting agency updates their report on the person. So what you're doing is you're putting in a piece of paper that's going to get checked up on later, and it's going to clear that person's credit report. There's probably other purposes for the satisfaction of judgment, but because I worked at two different collection agencies, that was our understanding. That's how we understood that's exactly the whole. That's what it would cause. It would cause the person's credit report to clear up, and so we followed the law religiously on that because we didn't want to get in trouble. You can get in trouble if you don't file a satisfaction of judgment when the judgment's been paid off. I think in small claims cases, the judges are going to understand that you just are a regular person and you might not know the rules. But if it's if it's a bigger case, if it's a firm involved, they're going to know that rule and they're going to follow it. If you're in a situation where you are a judgment debtor and your judgment creditor refuses to file a satisfaction of judgment, you can ask the court to file it. You're going to have to file a motion and it's going to take a little while, and the judge may get annoyed with the judgment creditor, or like I said, it may be a small claims case and the judge is just like, whatever, here you go, satisfaction of judgment entered, and they just don't punish the other person at all because they're understanding that the proceedings are informal and the other person just doesn't know how it works. So anyway, with that, I will see you guys next time.